Welcome to today's webinar. The Association of Justice and Treatment Professionals and its partners are pleased to bring you community courts, the why, the how, and the impacts. And we are very pleased that we also have experts who are going to assist us with today's webinar. But we're just going to wait a little bit for more people to join. But whilst that is occurring, I want to tell you that we are very pleased to have two experts with us today, Natalie Reyes and Lindsay Price Jackson, and I will tell you more about them in a moment. And so the Association of Justice and Treatment Professionals tries to create an environment to allow persons with lived experience, experts, practitioners, anybody with interest in the space, what we call the justice and treatment space, to come on and share ideas as we try to improve all the various justice and treatment partnerships through spreading knowledge and great ideas. There are some housekeeping issues. So the panelists are encouraged to keep their microphones muted until they are ready to talk. Now, one of the things that we love to do, really, is so important, is to engage you in conversation. And we tend to do that later on. And so if you've got questions, there's a Q&A button. Use the Q&A button, not the chat function. Just use the Q&A button to put in your questions and stuff. And at the end, one of my colleagues, Jennifer Graham, will do the Q&A, and we are looking forward to engaging you in that process. This is a team effort. And in addition to Natalie and Lindsay, there's Jennifer Graham, who's a Crown Attorney, Assistant Crown Attorney. There's Mary Pagani, who is a manager of PARC, and I'm only saying PARC because I've forgotten the full name. Kim Briggs, who is associate professor at the University of Western Ontario. Andre Rivard, who is duty counsel here in Peel. Together we make the team that tries to bring these webinars to you. And Natalie and Lindsay have kindly agreed that we can record the webinar. So when this is all done, we'll try and send you a link to it, and you can also see the recorded webinar at our website, www.justicetreatment.org. It takes us about 72 hours to get you that information. Check us out on Twitter, LinkedIn, and just subscribe to the mailing list at justicetreatment.org, just so that you know what's coming up and what we have available. And now I've looked, we have a fair group of people who have joined us. And so now is the time to do the land acknowledgement. So Jennifer.
Oh, I'm going to do it today. I have the distinct honor.
Actually, sorry. Sorry. I don't want to screw up because I just did. Mary, it's all yours.
Thank you so much. I have the distinct honor of being able to offer our land acknowledgement today. So we will begin this webinar by acknowledging that we are meeting on the Aboriginal land that has been inhabited by Indigenous peoples from the beginning. As settlers, we're grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. Long before today, as we gather here, there have been Aboriginal peoples who have been the stewards of this land. In particular, we acknowledge the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of Métis, Inuit, and other Indigenous peoples have made, both in shaping and strengthening this community in particular, and our province and country as a whole. As settlers, this recognition of the contributions and historic importance of Indigenous people must always be clearly and overtly connected to our collective commitment to make the promise and the challenge of truth and reconciliation real in our communities, and in particular, to bring justice to the lives lost in residential schools, as well as all the murdered and missing Indigenous women and girls across the country. And with that, I'll turn it over to Justice Barnes.
Thank you. Thank you. Thank you, Mary. Before we start, I want to talk to you, tell a story about Jonathan. Now, Jonathan operated like a grocery store and a bakery, right? And his pride and joy has been passed on in generations through his family. And so one morning, he got up very early one morning, looking forward to going to work. And he had what Jonathan would do is that he usually stop off at his famous coffee shop, and he gets his regular coffee, about a medium large special blend, quadruple cream, quadruple sugar. On this day, he picks up his coffee, he enjoys, he takes a deep breath. Oh God, what a wonderful morning. And he's taking a walk, going towards his shop. And as he gets to his shop, his heart sinks. He looks down and he notices that somebody has broken into his shop. But he says, not again. This happens almost every 2 or 3 months, and he knows exactly who did it. He didn't even bother to look for what had been stolen because he knew who had done it. He knew what had been stolen. So he gets on the phone, he calls the police and speaks to the officer and says, there's been a break-in, he has done it again. And the police know who he's talking about. He's talking about Julio. Julio usually every 2 or 3 months will come in, break in, you get arrested, you do some time, you come out and do it all over again. So anyways, Julio gets arrested for this. And for about 6 months, Jonathan is walking around and he's thinking, I've not seen Julio around over the last 6 months, but it's a fleeting thought. Almost like on cue, his wife Maria pops in and says, guess who I saw at the food bank? And she says, who? Julio. He's actually working in the food bank. And she looks shocked. He actually seems to have a stable job. And Jonathan was like, oh my God, how did that happen? And she said to him, he was talking about something called community courts. And Jonathan says, what the heck is community courts? Well, Natalie Reyes is going to be telling us about that. And Natalie Reyes is the Director of International Justice Initiatives and the Deputy Director of the Center for Court Innovation's National Training and Technical Assistance Team. In this role, she provides consulting services to jurisdictions implementing problem-solving approaches to justice with a special focus on community courts. Previously, she was Deputy Director at the Midtown Community Court. She holds a BS, Bachelor of Sciences in Psychology from Fordham University and a Juris Doctor from New York University School of Law. Natalie will be joined by Lindsay Jackson Price. And Lindsay is a senior program manager on the training and technical assistant team. With this team, she trains and consults with jurisdictions nationally and internationally as they implement community courts. Before joining the Center for Court Innovation, Lindsay conducted research and consulting projects with the United Nations University Delta 8.7 project on human trafficking, with the Arnold Ventures Pretrial Justice Initiative on local prosecutors nationwide, and with the Vera Institute of Justice. Lindsay began her career as a public defender at the Defender Association of Philadelphia, including volunteering in the problem-solving project Dawn Court for Women with criminal histories of drug and prostitution offenses, Lindsay holds a law degree from Penn State University and a Master of Public Administration from New York University. Ladies and gentlemen, these are our experts, and without further ado, I'll turn it to Natalie and Lindsay, who know who is going first.
Natalie will be going first, but I'll be sharing my screen.
All right.
Thank you so much, Justice Barnes, for that introduction, and to the Association of Justice and Treatment Court Professionals for offering this international space to talk about community courts. I'm really grateful and honored to be here with all of you today who have tuned in virtually. So, and thank you, Lindsay, for sharing your screen. So a bit of introductions. The Center for Court Innovation, where we both work, has the mission statement of creating a fair, effective, and humane justice system. And so we do this through three main areas. If you can skip, Lindsay. Thank you. So we do this through three main areas. So we have a few dozen operating programs in New York City, New York State, and New Jersey. These include two of the founding community courts in the US that have since inspired replications of community courts and other community justice initiatives across the world. We also have a strong research team that conducts rigorous data collection and monitoring to make sure that we are measuring what's working and can change course when something isn't working. And finally, we provide hands-on training and technical assistance to reformers around the world, including judges, attorneys, justice officials, community organizations, treatment professionals, and others who are also interested in achieving a more fair, effective, and humane justice system. Next. So here's a little bit of a visual of some of the areas in which we work as an organization. And actually what I'm going to tell you about today is a little bit of the story behind our organization that started in the early 90s. And I'm going to focus on sharing the community court experience in the United States. I know that in the next coming weeks, you'll be hearing from others about community justice centers in Ontario and in Vancouver. So next, please. So New York City in 1993 did not look like what it looks like now. Next, please. The neighborhood was at the time really, the neighborhood, the New York City as a whole at the time was experiencing really high rates of crime and a lot of violent crime as well. Data showed that actually out of the 22 police precincts, 40% of low-level crimes were taking place in 2 police precincts in Midtown Manhattan, Midtown North and Midtown South police precincts that really are the precincts that include Times Square, the theater district, a lot of transportation hubs, and a business district, a core business district, as well as residential community that lived in that area. So businesses and the community felt that these low-level crimes taking place were being ignored and felt that this was a real issue that wasn't being addressed because the responses at the downtown criminal court tended to be the same: 30 days jail or time served over and over again. And this was cyclical. So it seemed simple at the time, but the court was formed on a premise of accountability while offering help. It was created as an innovative response to people being arrested in the Midtown community. And the foundational idea was to link someone that had contact with the criminal justice system to social services and to veer away from incarceration. Next slide, please. So the Midtown Community Court was created in 1993, and it was placed in a building that actually was a theater. And the idea was that it could help people that were in the area and coming into contact with the justice system. It at first included 3 police precincts. It has now expanded to 6. It also included the Human Trafficking Intervention Court, which at the time meant that anybody who was arrested for prostitution charges in Manhattan was able to be redirected to Midtown Community Court to work with social services providers instead of going through the downtown criminal court. Also, Midtown Community Court provides mental health services borough-wide for anyone arrested in Manhattan, and has been an innovative place to respond to the opioid epidemic through, for example, its overdose avoidance and recovery court part. The idea behind the sentences that the Midtown Community Court gave is that they were served with immediacy, they were meaningful, visible, and they engaged new partners. The community really got to see through visible restitution that the justice system was working and was actually giving something back to the community. This started with community service in the traditional sense of cleaning up, of gardening projects, of cleaning graffiti, but it has evolved to, for example, supporting local nonprofits in the theater district, to supporting a food pantry where clients who were given community service could also leave with food and connection to social services themselves. There is a fatherhood and employment program that's housed in Midtown Community Court, because most of the clients that were being seen were really asking for help to connect with jobs. And so we have established at the Midtown Community Court some direct partnerships with businesses, business improvement districts, to actually get people that come through the program, or not. People can also receive services on a walk-in basis, connections to employment opportunities and training for that. And it's also the home to many new initiatives. So the Red Hook Community Justice Center, thanks Lindsay, which actually was formed a couple of years later, was launched on the ideas that were at the foundation of the Midtown Community Court, but this time in a very different residential neighborhood that was actually isolated from the rest of New York City, completely the opposite of the central business district in which Midtown was launched. So the community was involved in the planning of the Red Hook Community Justice Center from day zero, including picking the building in which it was going to be housed in, which actually was an area that straddled two different neighborhoods that often had tension. And so community members thought, well, this would be a really neutral spot to have a justice center. The planners engaged with AmeriCorps volunteers from the community that conducted a community survey and continued to engage residents throughout the entire planning process, which led to the Red Hook Community Justice Center being actually multi-jurisdictional. Instead of just hearing criminal cases, the community said they wanted to have a housing court there as well, so that they could bring complaints against the city when repairs and other issues were happening and the city was not being responsive in their buildings, as well as a family court where they hear cases that have to do with juvenile arrests. So the Red Hook Community Justice Center actually has a housing resource center, the Help Center, that provides housing, financial, legal assistance to folks to navigate housing court and resolve issues like critical repairs and prevent evictions. And Judge Calabrese, who is the presiding judge at the Red Hook Community Justice Center, has been known to actually going out to people's apartments to look at conditions of the damage in the apartments and hold the city accountable again through the housing court. So it is something that has really changed the way people look at the justice system, and follow-up surveys have shown that the Red Hook Community Justice Center actually did increase trust in the justice system because it was a new and innovative response. So we just gave one example of a community court and a community justice center. What does this mean? Next, please. So the term community justice, this is a mural actually that's in Red Hook at the Justice Center that spells out transform, and it was designed by participants, young people actually, and it is one of the rooms that is used there for social services. Thanks. So the term community justice is an alternative approach to a system that was seen as remote, bureaucratic, and ineffective. People were frustrated with the conventional legal system, its inability to really meet the needs of victims, of communities, of litigants, and to reduce crime. There was what was known as the revolving door. And so these are some of the guiding principles that really underlie community justice, both as how it began and where it is today. And the idea is that there is an opportunity to build trust between the justice system and local stakeholders by involving them in planning and operations, to develop new measures of success. So big here, you'll see a lot of kind of co-creating justice. The idea is recognizing again that communities are partners in the justice system. This could mean having an advisory board for the community court, opening its door to visitors, thinking really thoughtfully about space and what the implications are of a court for a community. And so making it more welcoming, maybe trauma-informed, accessible to folks. Putting people first, humanizing the justice system by centering the needs of the individuals and the communities that they serve. And also serving as a model to emerging issues and research. And so community courts have the opportunity, because they are housed in like neighborhood specific and neighborhood focused, they have the opportunity to look at problems and see if they can consider new solutions. Next, please. So what is a community court? So again, community courts are designed as an innovative criminal justice response that support the needs of a local community. It is an evolving model, but typically it's neighborhood focused. It brings the community and the justice system together. Here's criminal cases, usually low-level criminal cases, such as misdemeanors or violations, sometimes higher level. And also sometimes they're multi-jurisdictional. They can hear other cases such as family, civil, housing, re-entry as well, based on what is best suited for a particular community. The key here is linkages to social services and treatment. And the goal is to reduce incarceration and other system harms. So again, the focus is underlying community concerns and individual needs rather than issuing fines, jail sentences. Next, please. So community courts can serve very different neighborhoods. They can serve residential neighborhoods, downtown business districts, suburban, rural, citywide. You get the idea. Here are a few examples of community courts that the Center for Court Innovation has worked with in the US, and some of their, and actually one in Australia, in Melbourne, which is an international mentor court. If anyone is interested, they do a really fantastic job. And we can follow up with resources about their website if you're interested in seeing like how they've adapted the community court model in Australia. Next. The spaces, the idea here is that they are innovative. They can be in a courthouse. They can be a courtroom in a courthouse. They can be a standalone building that houses the community court and the social services. They can be based out of community locations, such as a library, shelter, community centers that have a lot of other locations, other services offered on site. And there are community courts that are even doing mobile outreach. They're going from different places to different communities, really getting closer to the communities they serve. Oftentimes community courts serve people who are experiencing homelessness. So this is a way for the resources to actually come to them and to also resolve perhaps some cases that they have and offer them help through the justice system. So when we think of a, thanks, Lindsay. When you think of a courtroom, you probably think of an old building. Community courts are really rethinking space through things like signage, language and accessibility, the use of modern technology, such as text message reminders, even in asking people what works for them in terms of scheduling their next court date or scheduling their services, training for the practitioners. A lot of what I just mentioned has its roots in what we call procedural justice, which is when the idea that research has shown that court users, if they perceive the justice system to be fair, they're more likely to comply with court orders and follow the law in the future, regardless of the outcome of their case. So the idea boiled down is that the justice system should treat everybody with dignity and respect, which I think we can all get behind. And there are four main elements here: allowing voice, so the participant's voice to be heard, feedback to be collected, their voice to really be heard, treating them with respect, understanding, so making sure that folks understand their rights, their obligations, the deliberations and decisions that are made about them, and that there is neutrality and that the decision makers are perceived as trustworthy and unbiased. as unbiased. And so community courts work really hard to put these elements into practice daily. Before we move on, actually, I want to note that I haven't mentioned this, but at the end of a community court case, which often folks have the option to opt into, they can still go through the traditional criminal court process if they would like, but if a community court is an option, then they will be offered this alternative. And the idea is that the disposition is more favorable to them. The idea is that it is different than the traditional system, and that they, by fulfilling the community court services, might get, for example, a case dismissed in the interest of justice, or lessened to a lower level charge, or dismissed in a few months, pending the completion of the services. So that's the goal there. So I want to show you now a few other courts and just highlight some of the mentor courts that the Center for Court Innovation has designated with assistance from the Bureau of Justice Assistance. These are 4 courts in the US that are across the country that also have done innovative things and have taken some of the principles that were created by Midtown Community Court and Red Hook Community Justice Center, but really made them their own, because there is no cookie cutter approach to community justice. So the South Dallas Community Court was established in 2004 in Dallas, Texas. And there are, since then, there are actually 4 additional community courts, all based on city council member districts. They have created different opportunities to support, for example, women who are in contact with the justice system and reentry over the past few years in partnership with a local jail. Next, please. The Orange County Community Court in California was established in 2008 in a community-based location that houses 10 different problem-solving court calendars, including drug treatment court, mental health court, and outreach court for folks that are homeless as well, that are experiencing homelessness. And they have service provider partners co-located in the building, and they also allow not just lower level cases, but they have offered these alternatives for folks that are charged with higher level cases. Next, please. The Spokane Community Court in Washington State. The first one was established in 2013, and it operates out of a public library, again, using innovative spaces where people can access rather than having to cross the city to go to their downtown court. And they have since also expanded to open 2 more locations out of community centers. And finally, the Olympia Community Court, which is one of the newest mentor courts, established in 2016. They have a dedicated building, and they have launched a community garden that is used as for community service opportunities, as well as providing food for participants and providing food to local food banks. And they're currently working on launching a peacemaking program utilizing restorative justice circles. And they're in the process of doing a needs assessment and working with community stakeholders to see what that could look like. So in summary, the bread and butter of community courts are really the social services and community engagement. And so if we could go back, Lindsay, the social services, the idea again behind this, you can go one forward, please, is that community courts can provide help to people by trying to solve the underlying problem that may have led them to the court system. So do they need an ID or paperwork to be processed to access public benefits? Does not having that ID present a barrier to them in their life? There is someone there to help make that happen that same day. Do they present with, on the other side of the spectrum, with serious substance use disorder and want to talk to somebody, or are willing to talk to somebody about the opportunity to be connected with everything from harm reduction tips and tools to detox and inpatient treatment? So community courts will have clinical social workers on site to help make these things happen. So how does this connection happen? There's usually a resource coordinator who's placed in the courtroom, and they serve as a liaison between the community court and all of the social services providers. So they don't all have to be on site, but sometimes they'll come on site that day, the community court day, or they'll have, for example, a once a week where they might come on site, or there could be navigators that help walk participants to the services. Next, please. And community engagement. So the idea here is really engaging neighborhoods and community members through responsive and meaningful programming. And throughout the last decade, community service has really undergone a shift too, in terms of changing community service from what you might traditionally think about in terms of cleaning up, but to making really meaningful and visible community projects and partnerships with residents, businesses, and different agencies. And the idea here is that we want to involve the most amount of voices as possible that actually are affected by community issues, including folks who have been arrested, into designing the programs. And so something that happened during, actually a little bit before even the pandemic, is that we started hearing that folks were doing community service oftentimes because they weren't interested in social services, right? So we would say, okay, you have a community service option. And we started hearing back from staff that really, as they were talking to the community service supervisors and staff, they were then getting to know them, building trust, and eventually they would be linked to the social services because they would open up and say, I could actually use XYZ, be happy to have that. And we would refer them to voluntary services. So the idea here, the important thing here is the importance of the strength of the people who are working at a community court. So having people who can relate to the people who they're serving, who will work and walk alongside them in the programming. And so I want to share what follows as a few quotes that have been shared with us after participating in community engagement, specifically at the Midtown Community Court, which did evolve during the pandemic to actually be a facilitated group discussion about community, about the justice system, about engaging their neighbors and engaging, with civic issues. So this program makes me feel like a somebody. What I'm learning is we all want to learn. Thank you for empowering us. I'm taking away a sense of awareness for my community. I did not know how much I really care for my community. This cycle is helping us to not be oblivious, coming together for a bigger picture. Community is profound. And I'm not happy I got in trouble, but honestly, if I hadn't, I would have never come here and met you guys. Groups like this could save someone's life. So these are beautiful quotes that can make us really feel good about the work we are doing. But it's not about us, right? So it's about how we can improve the systems that were built before any of us were born. So before I turn it over to Lindsay, I want to leave you with some feedback for the system from these community members. These all might not be, specifically related to what any of you work in, but these are things that we can consider as we strive to do this work, and consider what people are asking for here. So bookings, as in bookings by police officers and when they're in holding cells in police precincts, should have more posters and books. Give me some positive information. Give me some options to think about for when I get out of here. Judges should look at the good traits of someone. Use that when thinking about someone's sentence. If someone is good at something, they could teach others and that would be part of their community service. And finally, you have to hold people accountable, but you can't break their spirits. And with that, I'm going to turn it over to my colleague, Lindsay. Thank you.
All right. Thank you, everyone. Hello again. Appreciate being here. I'm going to talk a little bit now, transition a bit to, although probably at this point you're thinking this sounds really good, but does it actually work? And my short answer to that is yes, and my long answer are the next few slides. So we want to look, of course, before implementing a program, at what effect community courts have on both individuals who come through the court and the greater community where they reside. So All references to studies that I'll use in the next few slides will be sent in a handout we plan to send out to everyone after this. So if you choose to go read through some of the analysis and some of the research information, you will have that opportunity. So first, Natalie spoke about the Red Hook Community Justice Center, and these are some results from a evaluation done of that program, which was, you can sort of see between community court versus comparable individuals going through traditional court processes, that people going through community court received social services at an astoundingly higher rate, and on the same, on the same level, they were being put in jail for their charges far less often. Oops. Okay, and when talking a little bit more about results, this is still Red Hook Community Justice Center, that recidivism was examined by researchers here, and you can see that recidivism was 10% less at Red Hook. It was even more dramatic in other cases we're going to go over, but as far as cost savings, which are significant to many people, that they estimated as far as victimization costs. So think about if someone had reoffended, say kept breaking windows to shops, which was sort of an example we got early on, that $15 million by this one court were saved over time in costs to victims, that were saved because recidivism was reduced. And in fact, for every $2 that a jurisdiction, or rather for every $1 that a jurisdiction invested, that they saved overall $2. So that's cool to keep in mind when you're trying to pitch to your people, often people on the political level. So again, I had briefly mentioned another recidivism study, Spokane, Washington. In Spokane, a recent formal research evaluation found this, as you can see, significant difference between recidivism rates of community court and traditional criminal court routes for individuals with comparable cases and case histories. So they tried to, balance as much as possible, the researchers. And you can see that after a year, so that's that bottom line, after 12 months, after a year, less than a third of community court participants had recidivized, whereas nearly half of criminal case participants had done so. Which might not sound like too much of a difference, but in the aggregate and as you go on, it can be humongous. We'll talk about New York City here in a few minutes. So, okay, one more recidivism study. This comes from San Francisco, California. You can see in the image, it's maybe a little hard to see, but the community court jurisdictional geographical area is that blue line, inside that blue line. That's called a Tenderloin district of San Francisco. Whereas cases of similar profiles were examined in comparison that were in that red target area, so close neighbors, similar offenses, similar case participants, and what you can just see right there. I got a quote straight from the article. You can see there that people who had participated in the community court continued to be arrested at a less and lower and lower frequency over time, compared to their neighbors in that slightly larger red district. That. So their findings were that participation in community court statistically significantly reduced recidivism rates. All right, here's one more from Eugene, Oregon. This is the most recent study out of December 2020. And you can see perhaps most dramatically between these two bar charts what the differences were. So again, an independent evaluation likewise found significantly reduced recidivism rates for individuals who participated in community court compared to those with similar offenses and profiles, as we've been discussing participating in traditional community court. And the bar chart showing, you can see the community court recidivism rate. So that's rearrest rates right after participation in community court. That's the yellow bars. You can see compared to the blue bars, which is a comparison group in traditional community court. So in all three categories, you can see at the bottom, new arrest, new conviction, new incarceration. In all three of those categories, community court participants are significantly less likely within 1 year, that's how this was measured, within 1 year of the end of their case, I should say, to be arrested again, to receive a new conviction, or to be incarcerated again. So reducing recidivism, of course, related to the slide before, translates into large cost savings for jurisdictions who will save money on police time, court time, attorney time, prison time, many things. And we also mentioned victimization costs, as will be detailed in just a moment. So it looks a little grainy on my end, so sorry about that. But besides recidivism, in other words, getting a new case, non-appearance for court is also a very trying issue among low-level cases, because it leads to court delays and backups. We're seeing this from COVID very dramatically, and often triggers an arrest warrant or a bench warrant, which are also very costly, not to mention traumatic to enforce. So this is a chart from New York City's annual warrant report. So in New York City alone, as of January 2022, when this was published, there are over, as you can see, 1 million outstanding arrest warrants, and most of them are from low-level offenses. So as I'm sure you can relate to in your practice, consider how this might happen and why this might skew towards the low-level offenses. Perhaps someone is issued a summons for littering or something equally petty, right? But the court was too far from their home. They actually showed up, but it was too far from their home to keep waiting for their case to get called if they wanted to pick up their child from school on time. So they had to leave court before their case was called. Arrest warrant, right? Bench warrant for non-appearance. Or perhaps someone is experiencing housing insecurity and the summons that got sent to them never actually made it to them. The address wasn't good. And so now your alleged litterer, right, or whatever, is arrested at a traffic stop and taken to jail to await an additional hearing on this either bench warrant or arrest warrant. Meanwhile, their child is waiting at school to get picked up. And so here we go again with that loads of extra police time, court time, administrative time, jail time, all these things, and even perhaps child welfare investigations and proceedings, of course, all being paid for by tax dollars. And so this argument helps often folks who are trying to get allocation from their legislature to be able to say, oh, it's cost savings, but it's also the right thing to do. So research backs up that most failures to appear, so these non-appearances, especially for low-level offenses that we're seeing happen all the time, that they're not an issue of willful defiance or of people attempting to flee the jurisdiction and avoid, going to court for major crimes, but rather it's an issue of, according to the research, inattentiveness or simply lack of understanding or even knowledge at all. Usually, as I mentioned, for very low offenses. So researchers in New York City recently tested the idea of sending text message reminders to case participants to see if that helped people come to court more often instead of missing. For those those who were set on defying court orders and fleeing the jurisdiction, a text message wouldn't have changed anything. But researchers saw that for most case participants, it really did make a significant difference. So researchers estimated that this simple reminder, making sure that case participants actually knew their court date, helped avoid at least 30,000 arrest warrants over 3 years, and ultimately meant that, as they estimated, about 20,000 case participants ultimately got their cases dismissed rather than lingering on now with an open bench warrant. So this is an example of a core tenet of community courts, as Natalie discussed, understanding, right? Making sure, and that falls on us, doing the work to make sure that case participants actually know what's expected of them. And doing so can lead to significantly improved outcomes. We can see, I'm sure you've been in court many times where stuff just going over the participant's head, that all these legalese getting spoken back and forth, or speaking about a person, but not to them. And that inevitably can lead to system failures down the line. All right, another note on the cost savings. So this comes again from Eugene, and we're talking about the ROI, right? Return on investment, which again is often what your funders want to know. So here's a chart straight from the findings section of the Eugene research article. And check out the very bottom line of this budget analysis, which shows that after accounting for the costs of operating the Eugene Community Court, they are still saving over $51,000 per year by diverting participants to community court instead of hearing their cases in traditional criminal court. So that's a savings of about 27% to just this one jurisdiction. Older studies from the Red Hook Community Justice Center and Midtown Community Court also note that community courts increase public trust in justice, though that's harder to monetize, right? It is certainly a metric that should be considered when we're thinking about return on investment. Okay. So we've just reviewed several studies that came from meticulously collected community court data. Research is not an afterthought, right? And if you want to have data at the end to be able to make these sort of measurements and determinations, you really have to think about how you are collecting it at the beginning, right, on the front end. So involving directly impacted people, so people like your case participants, in this process can really help you identify what's important to them and what is more impactful in your program and in programs you can offer. Quantitatively, community courts measure how their programs have an impact on jail reduction. That's something a little easier to do by the numbers as compared to sort of qualitative information from your participants. But quantitatively, community courts can measure impact on jail use, on use of services, on cost savings, and on recidivism. So the center did recently publish, you can see the image here, an evaluation blueprint to help community courts who want to engage in this process and really help them build in data collection structures to pave the way for robust research of their program's efficacy and effects. Now, we are a little short on time, but I will whiz through what sort of next steps might mean for a jurisdiction who has decided, yes, this is something we want to do. And so it is what we would call implementation planning. And we, as technical assistance providers, we help guide and support these needs assessment activities, right? So you can see here that I've divided it into three sort of buckets along a timeline on planning and implementation, and then on training those who will be at work in your program, and then also to bear in mind those research and performance metrics that you want to bake into your daily data collection. All right, and here's some more things that really, as part of that implementation planning, need to be decided and spelled out before day one, likely in a policies and procedures manual before you launch your community court. So a lot of considerations, including the way cases will come into the court, where the court will be, right? What kind of cases you're going to accept. Will R&R means risk, needs, responsivity tools. So that means something almost like a survey, right, that you'll give to a participant to see where their needs may lie and what's the best mechanism we can use to deliver that. So that informs us as practitioners of what kind of social services we should be linking a participant to. And then if you're going to have outside partners in those social services or in community service, and really to decide, when is it done, right? When can a person be finished? And of course, making sure we have a plan for celebrating when those graduations do occur. So with all that in mind, let's bring our focus back to where we began, which of course is the members of our community. The genesis of all community court projects should be what community members themselves say that they want and need. The implementation should be done with community members really at top of mind, not with those funders who we try to please, right? But with the community members themselves. And community courts should perpetually continue seeking feedback from these community members and responding to their needs. So things like continued town hall meetings or annual reports that you make public statements about, and giving community surveys. So with creativity and with people at the forefront of our planning efforts, we really can make innovative justice reforms that will effectively serve both individuals in need and the community as a whole. And that's really what we're trying to do. And we're happy. I see that some questions have come in the Q&A and the chat, but we will definitely take a pause and see how we can answer your questions.
That's great. Thanks so much to both of you for that thought-provoking presentation. We do have a few questions, as you mentioned, Lindsay. So I'll take a stab at a few of them to put them to you, and whoever wants to answer them, whether it's either of you, both of you, whatever you prefer. So one of the questions was with regard to victims of crime. So, you know, as you know, they are another big piece of a criminal justice system. How do these particular centers ensure that the voices of victims of crime are heard and respected, and that, you know, the dignity that they ought to be shown is in fact taken into consideration?
Natalie, do you want to start?
Sure. I'll kick it off. So research has shown that incarceration is harmful, and we really can't incarcerate ourselves out of a public safety problem when it comes to the low-level charges that community courts seek to address. Something I want to point to that's really important, what Lindsay just mentioned, is risk-need responsivity theory, which is about really making sure that the programs address people's risk level, so risk level of reoffending. They address criminogenic needs, actually help people with their needs that lead to criminal cases, and that the program is really responsive. For example, there's been a lot of research showing that cognitive behavioral therapy is effective in supporting people through change and through behavior change. So the programs, I guess, for one thing, I want to say should really be thoughtful about, like, this isn't just an alternative and we're just trying to kind of do something that doesn't work, but this is something that the idea is that you're, you know, using evidence basis to provide programming that actually should work. But when it comes more specifically to victims and how they might have a voice, a lot of community justice initiatives are incorporating restorative justice programming that does include the victim and community voice. Sometimes other community members subbing in for like a victim, in the sense of if it's a lot of shoplifting cases, it might be like local business owners who might join as a community member in a restorative justice practice. And there are definitely ways that some community justice initiatives are being very deliberate about incorporating like specific victims in processes through restorative circles, and other ways that maybe not so direct, but are, again, like the idea of community restitution of harm is to address that there is accountability there, and that there is a response. It's a great question. Thank you.
Yeah, that's exactly what I was going to add. Talk about the peacemaking, the restorative circles, where victims are a huge part of that. But what I also wanted to add is something I've spoken with a lot of practitioners about is how it's punishment, right? And the thing is, with a lot of low-level crimes, when someone is incarcerated, let's say on the maximum, let's say 3 months for whatever it was. That we are seeing so often that 3 months jail time was not sufficient to convince someone to not do the crime, right? It didn't scare them away from it, but it also wasn't something that rehabilitated them, right? So what was it for? And so what we're trying to do is actually do that rehabilitative piece to make sure, or to really try to hope, and you can see by the reduced recidivism that there are no future victims, right? And so in that way, the idea to really focus on reducing recidivism is to improve community safety and reduce victimization in the future. Not a perfect question, not a perfect answer. Any victim's experience we have to give full, respect and credit to, but we also see that our participants are often victims themselves in different ways, and so try to look at people holistically, including the victim. So thanks for that reminder.
Thank you. We have a question from Michael here. It says he's interested in further unpacking what re-entry programming looks like from a community perspective. Do you have further resources or information about this that you can share?
Sure. So this can be done either directly through a community justice center. So for example, there was a community justice center in Harlem, New York, that for a very long time offered a reentry court, which combined not just, the idea was again to kind of do an innovative approach to reentry and have not just kind of parole officers working with a person who has been recently incarcerated, but then also having them working side by side with social workers and case managers that were part of the community justice center. And I can definitely share a resource of an example study that was done on that program, but also it can be done through programming. So walk-in programming, voluntary programming, or just programming that's developed in a community justice center can be geared towards folks who are re-entering society. So for example, the program that I mentioned at Midtown Community Court, which was really geared towards fathers who are also looking for employment. Many folks who enter that program are actually folks who have been incarcerated and they are connected to that program by their reentry. They don't have to have a court case at the community court to be in that program, but it's something that where, again, like if the community recognizes a need, then they can put that program in a community justice center.
Okay, we've got another question here that says, is there a measure of feasibility that must be considered or executed before such a center is created?
Yeah, I'll start with that. So that's really what the needs assessment is all about. When we go in and we didn't spend too much time on these slides, but when we conduct a needs assessment, it can be done by a jurisdiction by themselves. But when we, as technical assistance providers, are running these, what we do is we focus on local stakeholders, right? So we'll seek out members of the judiciary, members of the local business community, social service providers, other defense and prosecution staff, and people on the line staff, right? People in the courtroom, and also community advocacy groups or even victim advocacy groups. And we talk with them. We spend a significant amount of time asking them about what are the needs in the community and what are the wants in the community, and also finding out what are the resources in the community. So based on that, we're actually kind of getting to that, like, does it make sense, right? And you have to analyze this. It doesn't make sense in every jurisdiction. And sometimes the community will say, we don't want it. I think that Natalie gave a good example of the I think you mentioned the Brownsville Community Justice Center here in New York City, that there was planned to be a community court there, to have the formal court with the judge looking at low-level offenses, right? And the community said, we don't want it. We don't want it. And so at that point, it's not feasible, right? And what they did want was connection to voluntary services. You don't have to be tied to a court case to get help, right? You don't have to get arrested to be able to get mental health treatment, but to be able to have this resource center. So it can look different ways, and that's really what that initial needs assessment process is all about.
That's really helpful. Thanks so much. I'm cognizant of the time. We've got about a minute left. So there are some other questions. If either of you are okay with it, could we forward them to you? If I see you've been answering some in the Q&A as well. So thanks for that. If there's any others, is it okay if we forward them to you? Thanks so much. So thank you so much, both to Lindsay and Natalie, for this really great, informative, inspiring presentation. Up here in Ontario, we have some community justice centers that have been piloting, but we don't, it's not a regular thing up here yet. So I can assume that most people here on this call want to continue to work to get these types of centers up here if possible. So having this type of information is really great. So thank you very much to both of you for your time. And if I could plug our next webinar, we have May 26th at 1 p.m. We have Dana Aaron from the Ontario Community Justice Centers coming to present to us on what's happening up here. So for anyone who would like to join us, please register at our website, which is justicetreatment.org. You can follow us on Twitter and LinkedIn as well. So thank you so much, ladies. I'm sure we'll speak soon, and take care of yourselves, and thanks everyone for attending. Bye-bye.
Thank you so much.
Thank you.
It's our pleasure.